warrant used to search President Trump's home does not bear the seal of the court or the signature of the clerk as required by law. Title 28 U.S.C S 1691. Title 28 U.S.C S 1691 states that all writs and process issuing from a court of the United States shall bear the seal of the court and be signed by the clerk thereof. It is a statute that Congress passed, and they meant it to be obeyed. In 1860, the Supreme Court ruled in Aetna v. Doe that a warrant without the seal of the court is void when required by statute. In 1978, the Supreme Court ruled in Browder v. Director, Department of Corrections, Illinois, that the statutes hold supremacy over the rules of procedure. That means that even though there are rules of procedure they must follow, a statute must be followed first. In 2007, the Supreme Court ruled in Bowles v. Russell that we are not authorized to create an equitable exception to a jurisdictional. The use of unique circumstances is overruled. That means when a rule is jurisdictional, the court has no choice but to obey it. In 2009, the Supreme Court ruled in Splius v. Auburn Regional Medical Center that when the court determines if a rule is jurisdictional or not, it considers three factors: 1. Text. Does it use the word shall? 2. Context. Is the rule grounded in a statute? 3. Historical treatment. How has the rule been treated throughout its history? In this case, 28 U.S.C S 1691 meets all three requirements. It uses the word shall. It is grounded in a statute. Lastly, it has been law for over 150 years and the courts have ruled that a warrant without the seal of the court is void. This is why the warrant used to search President Trump's home is void and all evidence obtained from that search must be excluded. The federal courts in the Southern District of Florida are and have been committing fraud by not obeying the laws that Congress passed. The federal judges need to be impeached and the magistrates fired for their repeated violations of the law.